My fellow Gen Z babies might not know that back in the ancient era of the 1980s, Canada had blue laws. Blue laws essentially make it illegal to do certain activities, including commercial activities, on Sundays, the Christian Sabbath. So by the 1980s, consider this a ban on Sunday shopping, unless it's for absolute necessities like medicine and such. You picking up what I'm putting down? Good. Then let's talk about a surprisingly important Supreme Court case, R v Big M Drug Mart Ltd. It's Calgary on a Sunday in the May of 1982. The Charter of Rights and Freedoms is barely 2 months old, and ET won't grace our screens for another month. Big M Drug Mart, as a pharmacy, was allowed to be open today, selling its pharmaceutical necessities to the public. But if you've ever been in a pharmacy chain, you know that they don't just sell medicine. And Calgary police saw that Big M was also selling the forbidden fruit, a bike lock. And also groceries and cups, but they're not as funny. Consequently, Big M was charged with violating a big federal blue law, the Lord's Day Act. But because such a violation was a summary offense, they were only fined $40. Now, these fines weren't particularly unusual in the 1980s, and many businesses just took the fine as a cost of doing business on a Sunday. The two owners of Big M, though, they weren't having it. And so they took their $40 fine to court, got acquitted, and then the case got appealed. But at the appeal court, Big M and their lawyer used the Charter of Rights and Freedoms to argue against the Lord's Day Act and their fine, arguing that the law violated their freedom of religion. The appeal court ruled in favor of Big M, and the case got appealed again. And bada bing, bada boom, it's at the Supreme Court. Now, if you're keeping score at home, that's 2 appeals, a couple years, and a $40 fine going to the Supreme Court to perhaps define a new relationship between Christianity and law in Canada. After what I imagine to be some disbelief over the mildly bonkers nature of the case, the Supreme Court developed a new 2-step process to decide if the Lord's Day Act was constitutional. First, they would determine if the Charter, in this case Section 2 of the Charter, had been infringed upon, and if it had been infringed upon, could this infringement be justified under the Reasonable Limits Clause? The Supreme Court found that, yes, the Lord's Day Act infringed upon Canadians' freedom of conscience and religion, and no, this infringement was not justifiable under the Reasonable Limits Clause, finding the Lord's Day Act to be unconstitutional. And is that the end of the story? Did Sunday shoppers rejoice nationwide? Not really. Provinces themselves could and did still pass their own blue laws, and it took more than a decade for blue laws to truly be gone in Canada. So why did I just spend 2.5 minutes talking about a court ruling that didn't immediately change anything? Because sometimes landmark cases are historic because of the methods surrounding them. Because R v Big M Drug Mart was deliberated early in the life of the Charter, those methods used to decide the case have had huge impacts. That 2-step process I mentioned? Yeah, that became the basis of the Oakes test, which is the system by which the Supreme Court decides the constitutionality of all infringements on the Charter today. So the Big M case has directly impacted the last 40 years of the Canadian judiciary, even if its name is not widely known. This case is also an excellent example of the purposive approach to judicial interpretation. This approach is essentially generously interpreting the purpose behind the codified charter's meanings, even if those purposes aren't immediately clear from the words of the document. A lot of the most important civil rights cases in the common law tradition, cases that helped millions, were won because of this approach. So, even if this case is just a bit of a nothing burger, its buns, toppings, and fries are scrumptious and should be appreciated. If there's one thing I want you to take away from this video, it's that court rulings don't need to be a conclusion to be important. Thank you for watching. Please like, share, and subscribe for more loving videos about Canadian issues. Have a good one.